Deborah Williams, if you're in the courtroom, please unmute your microphone. Your Honor, I do request that the court take judicial notice of the return of service for Mrs. Williams that was executed on March 28th, 2025 and filed with the court April 1st of 2025.
So noted.
Thank you, Your Honor. And so the court is aware this filing is a confirmation of arrears of amounts owed by Ms. Carney to Ms. Williams, and thus we're not proceeding with serving Mr. Williams as there's no legal interest that he has in that subject matter. So, Your Honor, Mrs. Williams has not filed an answer. Her time for answer is passed, and the state is ready to proceed on a default.
You may proceed.
Thank you. I'd first call Ms. Carney. Ma'am, what is your full name?
Well, you have Janet Carney, but my current name is Janet C. David.
And you have one child before the court, and that's Raven Williams. Is that correct?
Yes.
And do you recall that there was an order signed December 6, 2004, requiring you to pay child support?
Yes, I believe that's the one with the CPS workers.
Yes. Your Honor, I request that the court take judicial notice of the order granting permanent managing conservatorship signed on December 6, 2004.
So noted.
And so, Ms. Carney, do you understand that under that order, Mrs. Debbie Williams was made permanent managing conservator of your child?
Yes, I was aware that she was the one that was gonna take care of my child, and that I would only be able to see her and have pictures or letters.
And so do you understand that under that order, you just still owe child support arrears?
That's what I've learned.
Your Honor, I'm offered evidence what's been marked for identification purposes as State's Exhibit A, a pay record, please.
Ms. Carney, do you have any objection to State's Exhibit A being admitted into evidence?
I don't know what that is.
You don't know. Have you shown it to her, Miss Sweet?
Yes, Your Honor, I did email it to her and while we were in the breakout room. Ms. Carney, if you would be able to your email, it should be from a program called DocuSign, allows you to open that State's Exhibit A, the pay record.
Okay, I'll check.
Do you have it, Miss Carney?
Yes. I see the email, and then it says view completed document, and it's loading.
Okay. Basically what it is a pay record to show all the payments you made or all the payments that came due and that you didn't make.
I see.
And now that you can see it, do you have any objections to that document being entered into evidence?
The only thing that I don't see on there is the payments that I made to Debbie. But those were cash payments, so I understand they're not.
So they would not be on the pay record.
Right.
Okay, so do you have any objection to the pay record being entered?
No.
Okay, then State's Exhibit A is admitted.
Thank you, Your Honor. So, Ms. Carney, do you understand that as of October 31st, our records indicate that your past due child support is $19,091.10?
Wow. I didn't realize it was that much. I thought it was lower.
And you had mentioned some direct payments of cash made to Miss Williams. Was that for support of your child?
Yes, it was after the signing. They were actually
Objection after yes, Your Honor, non-responsive.
Objection sustained. Ms. Carney, just answer the question that the attorney asked you, okay, ma'am?
Okay.
All right, thank you.
So how many cash payments did you make to Miss Williams?
Um, I made them for that year, and then I know I fell behind.
So you had
Um,
withdrawn cash from your bank account or paycheck or something like that, and then given it to Miss Williams. Is that correct?
Yes, it was that, and sometimes I would get the cash from her dad because I didn't have the money. So her dad would give me the money so I can pay it to Debbie.
So how much money had you given Miss Williams in cash outside of this court process or the state?
Um, I think I only gave her about, I believe I gave it to her for about 2 years. I was doing good for about 2 years with giving her payments.
And was that at the beginning of the case? So in 2005?
Yes, yes,
And
and
so
then
were they
I
monthly payments? Were they a consistent amount every month?
no, they were late. Um, well, they were consistent initially, and then I I fell behind, and that's when her dad would oh, that's when I would ask her dad to give me some money to pay to Debbie. Um,
And by her dad, you do mean Mr. Reuben Williams, the father of the child, correct?
yes.
So can you give a ballpark figure to the court about how much you believe that you gave her since 2005 in cash?
Oh, I don't know.
Do you recall how much the amounts were in the 2 years that you were making payments in cash?
Yes, I would give her 50. Sometimes I would give her 150. I think one time I gave her a $20 bill. um,
And your support payments under that order, you recall that they were $75 per month.
yes.
And then
Yes.
in June of 2005, they went up to $100 a month. Is that correct?
Actually, no, I thought they were $50 a month in
Um,
that order.
so, Ms. Carney, how often were you making these $50 to $150 payments?
Originally, I was making the monthly payments. I did that, I think, for a little over half a year. And then that's when I started to fall behind, I believe. And I still kept giving her cash.
Were you aware that under the order from 2004 that you were supposed to pay those payments through the state disbursement unit and not directly to Mrs. Williams?
No, no, I was not told that. Um, when I signed that document, it was with the CPS workers, and it was very emotional because they had told me that I would go to
Your Honor,
court.
narrative.
Objection sustained. Ms. Carney, again, please just answer the questions that Ms. Sweet asked you. I need to ask you a question. Do you have a ballpark figure of the total amount that you gave Ms. Williams in that 2-year period of time? Just tell me approximately how much money you gave her.
Um, I would think over 2,000.
Okay, thank you. You may proceed, Ms. Sweet.
Thank you, Your Honor. And Ms. Carney, are you requesting credit towards the arrears judgment in the amount that you believe you gave Mrs. Williams?
Yes, please, if that's possible.
Did you understand that after credit, the judgment as of yesterday would be $17,091.10?
Oh, okay.
And then do you understand that the state would then request that that be paid back at a rate of $135?
Oh, I thought you had mentioned 120.
Are you requesting that the $135 payment be lowered to 120?
Yes.
Do you understand that that would begin on December 1st?
Is that date able to be pushed out at all?
Objection non-responsive.
Objection sustained. Ms. Carney, just answer the question.
So, Ms. Carney, that payment would begin on December 1st. Do you understand that?
Yes.
And you also understand that you would be billed for court costs by the district clerk of Dallas County?
I did not know that. How much is that?
So I do not have the exact figure for you, ma'am, but they will bill you for it to cover today's court proceedings. Do you understand?
Okay.
And Your Honor, I passed the witness and would request a ruling as to the child support judgment payout and court costs.
Oh, grant the default order. Order a child support judgment of $17,000 even. Order that judgment paid at $120 per month. Order court costs as billed. All start dates will be December 1st, 2025. Ms. Carney, do you have any questions?
If I manage to get a hold of Debbie, about the adoption, is that something that can still be, resolved, like, with the payments?
I'm not sure what you're speaking of about the adoption. I don't, how old is this child?
She's 23, going on
Okay.
23 now.
And so was she adopted? Is that what you're saying?
Yes, she was adopted, but I searched for the county records and they did not have the record of that.
Okay.
So
So
she
you would
just,
have to speak with Miss Williams, and if Miss Williams wants to release any of this money, she can talk to the Attorney General's office.
okay.
Okay?
Okay, thank you.
All right. Thank you for appearing here today, and you're free to go.
Alrighty, bye.
Thank you, Your Honor.
We are hearing a suit for modification of support order and to confirm support arrearage, and we have an agreement, if I may state the terms.
You may.
The order contains a child support judgment against Mr. Barnes after a possession credit and after a release in the amount of $21,769.70 as of November 11th. That judgment will be payable at $150 per month beginning December 1st. There is also a medical support judgment against Mr. Barnes after a possession credit is applied in the amount of $18,092.91 as
Excuse
of
me, could you
November
repeat
11th.
that judgment, Mr. Tower?
$18,092.91, Judge.
Thank you.
That judgment will be payable at $100 per month beginning December 1st. Ms. Brown will be ordered to apply for or maintain the child on a government medical assistance program. Mr. Barnes will pay cash medical support of $50 per month beginning December 1st and guideline child support of $195 per month beginning December 1st. Court cost will be as billed to Mr. Barnes, and there's no request for a finding of non-disclosure. That's the extent of the order. If I may call the parties.
You may.
I'll call the mother. Ma'am, if you'll please unmute and state your full name.
Danielle Brown.
Did you hear the terms of the order that were stated to the court?
Yes.
You understand those terms?
Yes.
And are you in agreement with the terms and believe they are in the best interest of your child?
Yes.
Now, the child was residing with Mr. Barnes from August of 2023 to May of 2025. Is that correct?
Yes.
And after he is given a credit for that time period, he still has remaining. You are agreeing to release half of those remaining arrears. Is that correct?
Yes.
You're doing that freely and voluntarily?
Yes.
Have you been threatened or coerced into doing that in any way?
No.
And do you understand that once those funds have been released, you will not be able to get them back at a later date?
Yes.
Has there been any family violence between you and Mr. Barnes in the last 2 years?
No.
Do you have any other child support cases where family violence is a concern?
No.
In your prior order, your address and other identifying information were not included. Are you, or do you have any safety concerns about them being included in today's order?
No.
You pass the witness, Judge.
You may call your next witness.
Thank you. I'll call Mr. Barnes. Sir, would you please state your full name?
Larry Barnes.
Did you hear the terms of the order stated to the court?
Yeah.
Do you understand those terms?
Yeah.
And are you in agreement with the terms and believe they're in the best interest of your child?
It wasn't 23, it was actually 2022. But I agree to them, but I don't. So how can I refile?
Which portion of the terms do you not agree to?
It wasn't 2023.
Okay, let me explain this to you. Even if you were given a possession credit for the additional year, Ms. Brown has released over $21,000 of your arrears, which would be.
I get that, but the reason why I got my kids is the reason why I had got them.
Okay. I'll pass the witness, Judge. And if I could just briefly state that, I guess if Mr. Barnes is disputing the possession credit amount, the release that Ms. Brown is giving on top of the possession credit is well in excess of the additional year he'd be entitled to for a possession credit.
So Mr. Brown, you're not agreeing to this?
I would want to drop it.
You want to drop what, sir?
We was in agreement to drop child support, not take half off.
Okay, so you want to drop all the arrears, or you want to drop the
I
future
understand
child
the
support?
arrears. The agreement was to get off of child support, but I
Okay.
know about the arrears.
Okay. Well, Mr. Brown, even if y'all agree to that, I doubt if I'd agree to it,
Why is that?
because I believe it's in the best interest of your child for you to pay child support.
But I mean, the best interest of my child was she had a CPS case. So
But
that's why I ended up getting
Mr.
my
Brown,
kids.
Mr. Barnes, that's in the past. You've allowed the child to go back to her now, correct?
I did, but my child actually went back to her because I had a dispute with my cars. So it wasn't like she just wanted to go back. My child wanted to be with me.
Okay, well then maybe you need to file for to become the primary caregiver of your child.
I mean, I didn't want her on child support. I just wanted to drop. We planned on dropping.
Okay, well, sir, I'm going to mark this as a contested hearing, and I will tell you, I will accept the agreed portions of this order, make
Okay.
those agreed portions the order of the court. I will
Okay.
order you to pay cash medical support of $50 a month and order you to pay child support of $195 a month. Now that I've made my ruling, if you don't like it, if you think it's not fair, if you don't agree with it, you have 3 days to appeal, 30 days to file a motion for new trial. Now
Okay.
that I've given you all that information, do you have any questions?
That's it.
All right. Then thank you for appearing. Thank you both for appearing here today, and you're both free to go.